Mine, yours, and ours, sorting out separate property in divorce. One of the larger issues that we face in divorce law is what is separate property and what is considered marital property. Colorado is not a community property state. We're an equitable division state. And we do separate out a separate property or separate property interest prior to dividing the marital estate or property that was acquired during the marriage. So what is separate property? Separate property can be items, assets, money you may have obtained through a gift or inheritance. It can be property that you had prior to marriage, or it can be property that you and your spouse, either before marriage or during the marriage, have decided that you are going to consider that particular asset to be separate property. If it is by agreement, you must have very good proof that there is an agreement between you and your spouse prior to the divorce or the divorce process that this particular asset is a separate property asset. It is always best to have it in writing, and it is always best to consult with an attorney just to ask to make sure that if you want to consider it a separate property asset, it is being written in such a way. So the other issue that can be a little bit tricky is gifts. Gifts to one spouse may be considered that spouse's separate property, and that can be a little bit tricky when the asset is titled jointly but is given, for example, as maybe a Christmas gift or a birthday gift. There is a presumption in Colorado law that says if the asset is titled jointly, it's a presumed gift to the marriage and not just to one spouse. So that's just something to consider with gifts. Even if the property is considered separate property, any increase in value or appreciation in the asset may be considered marital if appreciated or increase in value occurred during the marriage. So that is the other thing that you must consider. An easy example is a 401k plan. If you had a 401k plan prior to marriage, that has a value on that date of your marriage. We would look at that value as of the date of the marriage and say, this is your separate property. Then we would look at the increase in that particular account if it did increase, and that increase during the marriage would be the portion that is subject to division and is considered part of the marital estate. The other thing to consider is that in Colorado, we value property as of the date of the hearing on property or the date of the decree, which is the legal document that the court gives you that legally severs or terminates the marriage. We do not use the date of separation. So even if you separate from your spouse maybe a year or two before filing for divorce, the law will still require the assets to be valued at the time of divorce and not at the time of separation. So that is something else to consider when thinking about what has been separate property in a marriage and what has become marital property in a marriage in attempting to divide the assets fairly and equitably. This is our video on mine, yours, and ours, sorting out separate property in a divorce. We hope this was informational to you. If you have any comments or would like to hear more information on this topic, please leave a comment below and we would love to hear from you.